As the study and this summary have illustrated, the administration of the death penalty in India is manifestly flawed and fraught with error. This situation has gone on unaddressed in a meaningful manner since the country has gained independence in 1947. As the world moves steadily away from the use of the death penalty, the time has come for the Indian authorities to abolish this, what we can say, outmoded form of punishment. The leaders of India may lack the political courage and the human rights leadership necessary to abolish the death penalty. Public opinion often supports the retention of the death penalty based on the erroneous view that the deters violent crime. It is therefore up to the nation's leadership to explain the futility of the retaining executions on this basis and to convey the unacceptability of such grave human rights violation committed in the name of people via the country's judicial system. The Indian state argues that the death penalty is required to instill the fear as a means to deterring future criminals and to safeguard the society against raising the crime and the terrorist act. In 1995, the Indian government told the UN Human Rights Committee that the death penalty has been retained in the Indian statutes legally in view of its deterrent value. Yet, evidence from around the world does not support the deterrence argument. The most recent comprehensive survey of research finding on the relation between the death penalty and the homicide rates conducted for the United Nations in 1988 and up-to-date in 2002 concluded. It says that it is not prudent to accept the hypothesis that capital punishment deters murder to a marginally greater extent than does the threat and applications of the supposedly lesser punishment of the life imprisonment. In addition to the adoption of mandatory death sentence in 1980 and the inclusion of the death penalty in successive anti-terrorist legislation since 1990, there have been discussion in the government about the including the death penalty for the several other crimes in response to the public outcries about crime rising and the ineffectiveness of the criminal justice system. The death penalty of the dangerous driving was reported to be under the consideration in 1997. As has the death penalty for rape since 1990 and for the sale and manufacture of counterfeit medicine in 2003. These considerations were there. It is to be welcomed that sense has so far prevailed in such debates about expanding the death penalty still further as the means of addressing these problems. Such proposals simply distract attention from the measures that might properly address the serious problems of the violent crime. In refusing over the years to declare the death penalty unconstitutional, the Supreme Court of India has relied on the fact that those framing the Constitution did not see fit abolish capital punishment, and that the legislature has subsequently not done so. In turn, the failure of the Supreme Court to strike down the capital punishment has become the rationale for the Indian state to deny and need to re-examine the relevance of the death penalty provisions in Indian law or to abolish the punishment. This cycle of inertia needed to be broken, and the reality of the death penalty exposed as both unfair and ineffective and speedily acted on. The argument for abolish the death penalty remains forceful and persuasive. State killing condones violence and brutalizes society. The ever-present risk of the executions of the innocent is enhanced by an unsafe judicial system. Disadvantaged sections of society, usually the poor and minorities, are the disproportionately at risk of